Well, good morning, everyone. I'm Tanguy van Overstraeten. I'm a partner of Linklaters. I'm heading actually the data protection practice at Linklaters with, I would say, over 20 years in that field. I'm very glad to welcome you today for this session, which I hope to be as interactive as possible. I would like first to give a word of excuse for Bruno Giancarelli. Bruno was supposed to join us this morning, but as you may already know, he has become the new head of the privacy unit at the DG Justice. And while yesterday night he had a very important meeting that he could not avoid, so he will join us, but later on today. As a result of that, I'm very, very glad to welcome Thomas Zerdick. I believe you all know Thomas. Thomas has been working for the European Commission for quite some years. He is currently head of sector data protection reform in the personal data protection unit at the European Commission. He has a background as a German lawyer. He was graduated from the German university in Passau, but also from the College of Europe. Next to me on the right-hand side, left-hand side for you, is Christian Kuna. Christian is working for the EDPS, and Christian especially focuses on the implication for privacy in the field of competition law, but also in relation to consumer welfare, in relation to big data and digital economy. And on my left side, so right side for you, is Annamaria Mangiaracina. Annamaria is a partner of our Brussels office at Linklaters. She is focusing on competition law and especially on global cartel investigations. So today what we are trying to do is in fact giving you the practicals and the tips in relation to investigations and the needs to comply with data protection in that perspective. The idea was to use a case study in relation to a competition law investigation, but in fact this could apply in any setting where there is investigation. That could be when we receive a subpoena, that could be in the framework of discovery or e-discovery. All that, I think, would make it applicable. What we have done is that we have divided, in fact, of course, we will explain the case study itself, but we have divided the presentations in 6 challenges that we want to present as role play. So we will play roles to explain and to highlight the difficulties that can be faced when you have these challenges. And then we will come to practical and concrete recommendations. And again, I think it's really to find out how to capture the need for compliance of data protection in the framework of investigation. So I will give the floor first to Annamaria to explain the case study.
Good morning, everyone. As Tanguy explained, we have a case study that we have sort of depicted for the purposes of today's presentation. So the purpose of today of my explanation of the case study is to give you a bit what is going to be in the background to our challenges. The first point is that we have a company, we call him Cranecraft, headquartered in Korea. They have a number of locations across the world, but importantly for our own purposes is to know that their European headquarters is in Europe, is in Belgium. What do? They do a number of different activities. They are building, construction, so they do not only business to business, but also to business to consumers. So their interaction is at different level within the industry. What has happened? There is an investigation. So now we get into a typical scenario that I would meet when I'm dealing with a cartel, which is that our client or representative of the clients, of Cranecraft in this case, have been meeting with competitors. There have been a number of price increases observed in the sector, and the end-year results were absolutely astonishing. The market, but also the customer, starts to become a bit suspicious. What's wrong in the industry? Why everything is changing? And a number of investigations are being launched by regulators across the world, including the European regulators, Korea and US. And at the same time, a class action is launched by U.S. customer. Now, this is the scenario that we are giving for the purposes of today, but I should say this is quite a common scenario that you have in a cartel case in terms of how the different steps evolve. Why it is important, what happens within the company once Cranecraft has learned that this is happening and this has happened. Now, I would like to give you a 2-minute illustration of how, from a competition law perspective, finding out of a cartel existence replicates in terms of what the company needs to do. In the European system, but also the US system, there is something which is called immunity, leniency, or amnesty. What means in practice is that if you are the first company that tells the regulator, be it the European Commission in this case or the US Department of Justice, that the cartel is in existence, you will get a benefit, which is you're not going to pay any fine, so you get full amnesty or full immunity. But in order to do so, you need to fulfill a number of requirements that in the European Union are set out by a notice, a commission notice. And these are what we have here in these slides. You have to be the first one to report. You have to continuously cooperate with the authorities. You have to provide all the relevant evidence which is available to you. You have, of course, to end your involvement in the cartel. And you have to bring evidence which brings added value, which means that would allow the European Commission or the US authorities to start an investigation. In the US, this is called the amnesty. The important takeaway from this slide is time is of essence. Why? You have to run to be the first, and to be the first means you have to be quick. There's no time to wait, there's no time to waste. And this is what happens, and this is when, I would say, our role play starts, because this is the background, this is where Cranecraft is sitting. We have our own actors, it's ourselves. Myself, I would be playing the general counsel of Cranecraft. Tanguy will be the data protection officer within Cranecraft. Then we have a local privacy regulator, Christian, and on the other hand, the EU privacy regulator, Thomas. So the idea is really to just explain the 6 challenges, starting with a small role play. You know, what happens from the company perspective, what happens from the regulatory perspective, and then just go through what are our solutions and our recommendations about to tackle those challenges. So we start with the first challenge, which is really, we set up the slide here. So I'm now the general counsel. So you know, Tanguy, I mean, we have all the instruction that we need from management, and we know that, you know, what we need to do, but all I need is really to collect all data, emails, agendas from this individual, because I need to provide it to the authorities. Can you please help me with that, because you are the data officer?
Well, Annamaria, I'm sorry, but I'm not the data officer per se. I'm the data protection officer. And obviously that means that I have also to draw your attention to the need to comply with data protection laws. So let's move on and see how we can do that.
Okay, just go ahead. Just give me a bit of an overview so that I know what I have to do.
Sure. Well, in fact, the key point is that we have a setting with our main company in Europe being in Belgium. So you figure out that we have a data protection directive that could apply throughout all the establishments that we have in Europe, but unfortunately it is not fully the case. In fact, we have several different national laws that we have to comply with. So, and at least as many regulators, in fact, as we are also in Germany, we will have to comply with several regulators because we have several establishments in Germany. So this is a more complex relationship that we have to set up. Well, and looking at... Is that working? Yes. Okay. Now, turning at the recommendation themselves, I think it is important really to first look at the countries in which you are established when you do that. And please consider always what we have already mentioned to you. Time is of the essence, so you don't have much time to do that. So the best is to anticipate, to look at this, and to, in fact, have in place the tools that enables you to answer any request that may come forward and that you may not necessarily know in advance. So the thing is that you should run a legal survey to determine what are the rules, so to investigate, in fact, what sort of requirements you may have that, as I said, may differ from one country to the other. As you all know, this may change in the future, but currently we still have a directive not directly applicable in all the member states, and we still have as many authorities as there are member states and more. So what is, I think, important is set up a network of local experts. Sometimes you can rely on an international law firm. Sometimes you can rely on your own resources. It depends, of course, on the size of the company. And therefore, you should also involve the various departments of your organization. You should not only focus on legal or compliance, but you have also to collect information from HR, from marketing, from IT, from security, to set up the organization and make sure that you have captured all information that are relevant and therefore apply the rules as they are suitable for the investigation itself. So I think, again, what is important is really to look at this from the outset and not wait for an investigation to start.
Okay, that sounds all good and well, but really all I need is this data. So can we just think about what we should do from the European perspective? So let's look at European law. I mean, I really run against time, and if I'm late, I'm losing my amnesty and leniency. It's going to be a very big fine.
Well, again, you have to be very careful, Annamaria. There are limits to what we can do with these data. And I believe it's fair to call our regulator because I think there are differences to be made. One case is that you may have a compulsory situation where you are obliged to provide the data, or you do it on a voluntary basis because there is a need you want to have leniency or amnesty. That, I think, is a very important distinction. The second distinction to be made is that when the legal obligation or where the voluntary action comes from EU member state because you want to respond to a request that could also be the European Commission, or where you want to comply with non-EU obligations. And last but not least, I know that it is very difficult to obtain to justify the processing based on consent, on prior consent. Why? Because, first of all, most of the data that we are collecting are related to employees, and given, they cannot give their consent freely because of the subordination link. But also, we always face the risk that the employees will refuse or may refuse, or later on withdraw their consent. So let's turn to our regulator and ask for the best solution here.
Thank you for contacting us, Tanguy. It's always a good idea to pick up the phone and speak to the Data Protection Authority if you are unsure about some of your data processing. You obviously need a legal ground, as you're aware, in order for the processing to be lawful. Just to be clear on what we mean by processing, it includes storing data over a particular period of time, the retention of data. It includes disclosing data, which is what we're talking about now in relation to this competition investigation. It includes onward transfer as well within your company, within the EU, and to your subsidiaries outside the EU. In terms of a legal ground, you've already explained that consent, unambiguous consent under the Data Protection Directive is tricky in this context. Given your time constraints and given the nature of the investigation, it may not be appropriate or feasible. There are other possibilities which are provided for under the law. One of them is the performance of a contract. That doesn't seem to be relevant here. Another is for compliance with a legal obligation. Now that could be an appropriate legal basis. You may have trouble though if this is an investigation from a non-EU competition authority, because there, unless you have a formal mutual legal assistance request where your own national court has demanded certain data, then it's not a valid legal basis to transfer that data to a foreign court or to a foreign competition authority. Other possibilities: the vital interests of a data subject doesn't look like that's appropriate here. Are you performing a task in the public interest? It's possible, but it's unlikely. We, as data protection authorities, take quite a restrictive view of what the public interest is. It should be laid out in national legislation. In the new data protection regulation, it will be even more restricted. That leaves you with your legitimate interests as a company, and this is perhaps more promising for you, but it requires a bit of work and analysis. You need to make a judgment on to what extent your perceived need to provide as much information as possible in order to facilitate the investigation, and balance that against the rights of the individuals whose data you're processing, whether they're employers or former employees or former employees. They could be suppliers or competitors. So you really need to look at the circumstances there. But I think that's probably the most likely legal basis for what you want to do.
Okay, that's all well, so I got it. We need to find the legal ground. But let me just give you an example of the type of document we would like to use. This is an extract of our client relationship management database. Would do? I mean, can we just get this to the authority?
Well, before Christian answer, why don't we ask the audience? What do you think about this list? Is that something that we can use per se and, start sharing with the authorities, start sharing with law firms to investigate, etc.? Who has a reaction on that? Do you like all these data that can be disclosed? No problem?
Hands up for those who want to do it. Hands up. Show hands who want to send all of this.
If you want to hands. It's difficult to see you because of the light.
If you take out some of the data, not all of that is necessary to share. So you want
and which data don't you like?
There is no reason to have people's status in there. You could have their job, their age even could probably come out. And actually, do you need to name the individuals? Possibly not. If you have actually a job.
I agree. Mm-hmm.
So as little as possible.
Well, in fact, we have highlighted a number of points. One is, as you said, the age and the status, that I think is important and probably unnecessary. Depends, of course, you have to address that on a case-by-case basis. Then you have the date. Some of these data are completely out of date. And then last, you have information that can be sensitive. But I will give now the floor to our regulator on this.
Well, Tanguy, you seem to have understood the basics here.
Thank you.
So, you're absolutely right. I mean, the principle of data minimization is crucial here. You don't need what do you really need to supply as part of your leniency application? What information do the authorities really need for their investigation? Do you consider? You need to consider a number of things. You need to consider the impact, the consequences for the individuals concerned of disclosing this data to a third party. You should also think about different techniques for improving the privacy, the protection. So, is it possible to redact this information? As our colleague has said, do you need to have the names Could you pseudonymize them or anonymize them? You could also consider using encryption techniques for particular fields of data, so that the access to that information will be much more restricted. As you said, sensitive data, there are some very specific and strict rules about how that should be treated, and you would need explicit consent there. I hope that was helpful.
Yes, it was. But I mean, all I'm hearing is, okay, we have a legal ground. We need to be proportional and try to make sure the data that we provide are the right data. But really, I mean, the management is getting impatient. As I explained you, we have to hurry up. And more importantly, we have to be discreet about this process. I mean, we risk losing our leniency status before the European Commission if everyone gets to know that we have applied. So can you just try to sort it out with the employees as soon as possible?
Well, you're right, Annamaria. We are almost all set, although we have to address a couple of other challenges, but I'm sorry to say that we cannot do that in secret. There is a principle that is very important, which is transparency. And as you know, we are facing in the company a number of different bodies or different persons. We have, of course, the employees and the social bodies of the company. We have also the regulators, and we have also the customers, the representatives of the customers and the suppliers and their representatives. So it's very important to organize the information to those bodies. And let me take one by one. First of all, towards individuals, and I'm talking primarily towards actually the employees first, you have multiple information channels. One that could be, of course, is to modify their employment agreements, but this is something you cannot do at once. You have to organize yourself. Again, anticipate will be important. You may address in their employment agreements or addendum to existing employment agreements specific clauses in relation to potential investigation and the fact that some of their information may be shared from time to time. If this has not been foreseen, and as you know, the issue of consent we have already raised is a difficult one, you may want also to explore that, and you may have to do it in some countries through modifications of the works regulation. And then you have to address the issue to the bodies in charge of the employees, so the Works Council in most countries. You have to consult them, you have to inform them. Sometimes in some countries you have also to get their approval. You have also other form of information. It could be a part of a training. We have seen that in many companies that they have regular trainings, and some of them may cover data protection. It could be also information on the billboard. All depends, of course, on how you communicate with the employees within the company. Again, intranet could also be a good solution. When you look at the customers and the suppliers, if you have to start sharing information, you will have to start sharing basically personal data, which means that you are going to share information about the representatives. In most cases, your agreements will be with the companies themselves, so with the legal entities. So the only way, I believe, and we can discuss that, of course, you can address that, is to delegate the obligation of information to the companies themselves as employers so that they inform their employees, and including, of course, the representatives with whom you are in contact, in relationship, of the elements of the fact that you may have to share information about them in the framework of investigations. That could be in the terms and conditions, that could be in the service agreements that you have in place. It's something that you have to think about. And, well, if it is not anticipated, again, you may face lots of difficulties to do that at once when the time is come that you have to share this information. If, because we said Cranecraft is also a company dealing with consumers, it's a B2C business, Well, that, again, you have to inform the consumers to the extent, of course, it is relevant, because I think in the framework of an investigation, it's relatively unlikely that you will have to use information that relates to consumers per se. But if it is the case, it would be important to add information, for instance, in the online privacy policy if you have an e-business platform. Vis-à-vis the regulators, I think it is also very important to be very careful. One is that you can consider that there are some existing notifications that you could explore and see whether they would cover this kind of information. But the likelihood is relatively remote. So the best is to really build in a standard procedure to anticipate that, and have a notification in all the countries which require a specific notification to cover that well ahead of time. So to inform, in fact, the regulators that from time to time you may have to respond to a request for investigation. That doesn't prevent you from, of course, being also transparent when the request for investigation occurs, but at least you have also already paved the way to enable it, and that will help you, of course. Last but not least, information is one element, but it's not enough. You have also to comply with the rights of the data subjects. And those rights, as you know, include the right of access, the right for correction, for deletion in certain instances. So you have also to put the procedure in place to enable them to do that. And, well, if you are on the spotlight and you have to do it immediately, well, in the information you will provide to the Works Council, to the employee, also think about the DPO, the Data Protection Officer, whenever there is one in the company, that you will have to inform them about the process that could be in place, the procedure they have to follow if they want to have access to their data. So I think that's the way to respond to this important principle of transparency.
Thanks for that clarification, Tanguy. I mean, I take all these points, but now one additional challenge which I'm facing is that our headquarters in Korea want the data. The same goes for the US, where we have a class action pending. Can you just tell me how quickly can we respond to this request? How quickly can we transfer this data?
Well, of course, Annamaria. Well, in fact, again, here we have to be careful. As you can see from the slide, the circulation of data within the European Union is in principle free, but as soon as you are talking about transferring data to a non-EU country, you have to be very careful whether or not it is adequate, like Switzerland in this chart, or if it's not adequate, we have to find solutions. And there, I would like to turn to our European regulator. Thomas, what do you think about that, please?
Cher ami Tanguy, how are you doing? Very well to hear you. First, of course, I assume that all the data you would like to transfer are fully compliant already with the requirements under the directive. So, because you can only transfer something abroad which has been lawfully processed in the EU in the first place. So I assume that's done. And I assume also that you have done the check if it's really needed to do a transfer of personal data. So if you can transfer anonymously, perfect. If you can transfer with pseudonymized data, even better. But I assume you've done your checks and your legal things.
I can confirm that.
That's wonderful. Because, you know, we must ensure continuity of protection when personal data is transferred outside the European Economic Area. That's what the directive requires you to do. You mentioned Korea. Well, I'm afraid there is no Commission adequacy decision as to Korea, so there's no way you can just transfer to Korea. There is for the United States in the safe harbor, but this doesn't cover your case here because it doesn't apply to public authorities, and therefore that path doesn't work for you. So we probably have to you have to employ one of the derogations in Article 26, 1 of the directive, and that would be unambiguous consent. But again, I assume that the data you transfer from the people involved is quite a few, and it's unlikely that you would get all the unambiguous consent for that specific transfer on time. So I'd advise against using that. By the way, it's pretty easy to do this check. You just need to take the directive, open up Article 26, and read and run through those conditions.
Thank you for this valuable information.
More than welcome. We get those questions a lot. You have contractual necessity. There again, I don't see, you don't have a contract between the data subject and the controller for pre-contractual measures, so that doesn't fly. You have no contract, so no contractual basis is allowed. Now it gets interesting. We have the transfer is necessary for the establishment, exercise, or defense of legal claims. Now, here definitely I think you're on the good ground, because this is the establishment of a legal claim in the wider sense. Leniency application is you're trying to get a good, advantageous legal position for your company, and that is towards a public authority in a third country, which, if you don't do this, might bring you in a complicated legal situation, and then you'd have to defend yourselves in that jurisdiction. So I think we're onto something here. But let me just run through the other possibilities as well. Public interest, obviously, competition cases, this is a European Union competence where the European Commission has powers to have companies behave in the marketplace as they should be, is something which is in the public interest. As the transfer you're doing here to Korea or the US, this must be something which is in the public interest of the European Union. So it's not good enough that a third country's public interest is invoked. This is a bit shaky here, so don't go that road. Vital interest of the data subject, certainly not. It's your interest of the company, but none of the interest really of the people who are involved. So, other specific grounds, you're not talking about a register here. So we're getting to the end of this exercise, Tanguy. You might want to think of safeguards, appropriate safeguards. You also always have the possibility to go to your local regulator, the local data protection supervisor authorities, and explain them the issue, explain them the case, and obtain an authorization. But that's probably going to take you some time, because not all of the regulators are responding at the same time and in the same quick time frame. But it's possible. Standard contractual clauses which come from the European Commission, great way of transferring with good, adequate protection, but unlikely that if you offer this to the Korean authorities that they will sign this and abide by them. So you can try, but tell me what came out of that. Again, bespoke clauses, specific standard contractual clauses, they might work, but again, not in the context of a leniency and competition case. They just don't work for public authorities, and you would need an authorization, again, from a supervisory authority or several supervisory authorities. Also, binding corporate rules, that's fine, that works for you and the companies you control. But then again, that doesn't work for public authorities in third countries. So I guess it's a no. If you wanna wrap that up.
Thank you. So in fact, I think what is important to note is that if you are within the EU, you all know, of course, that you could centralize the data, for instance, in the EU headquarters, which is in our case study, Belgium, but you obviously have to comply with all the other obligations under the directive. Transfer of outside of the EU, so to Korea, for instance, the US for class action and so on. I believe Thomas has summarized really the key issues. The defense of a legal claim could be one. It's interesting because you can also justify that by the corporate interest of the group itself. So it could also be a way to motivate, to justify the defense of a legal claim. The model clause, I would not necessarily set them completely aside because you may have situations where you need to transfer data, let's say, for instance, to a law firm, so that that law firm can start reviewing the data and using keywords and try to identify which data may have to be ultimately sent to the authority. But of course, you shouldn't do that in a way that you will circumvent the use of those model clauses. So you should make sure that when you are signing off the model clauses, it is only for that specific purpose, and you would have to select which one you need. Will the law firm be considered as a processor? That's probably likely, but it could be there could be some instances where they go beyond the role of a processor, and then you would have to select the data controller clauses. I think the bottom line is really the defense of a legal claim, but the potential of the model clause should be explored. Beware that if you are using the model clauses with the data controller setting, you cannot do onward transfer as you wish. There are some specific constraints that should apply. The public interest, I think, is also a bit debatable. I took note of what Thomas has said, but obviously the leniency, the amnesty, the bottom line of these tools are to make sure that cartel does not occur. And that is, in fact, the bottom line. And well, this could be an interest that is also shared by the European institutions. It is, in fact, in reality. And so public interest could also be considered. But I think it is clear that the defense of a legal claim is the most justifiable ground for transfer here. Yes,
okay. Tanguy, this is Christian again. I've just been looking at your notification. Generally, it seems to be in order, but I've noticed that you're monitoring staff emails at Cranecraft.
That's correct, indeed.
You're aware that people are entitled to a degree of privacy in the workplace. What sort of safeguards do you have in relation to this monitoring activity?
Well, that was, I can tell you, a difficult exercise because, indeed, to ensure the respect of the rules in relation to that, you cannot only rely on data protection, but you have also to look at the telecom secrecy. There are some specific rules on that in many member states. And unfortunately, there is no one-fits-all solution. You have actually to look at each member state's legislation to determine how you can transfer the data, how you can access the data, and sort of monitor the content of the communication. And the communication is not only like in the old days, the voice telephony, so the tapping, in fact, but it is also in relation to email, so point-to-point communication, electronic communication, where you have to distinguish between the traffic and also the content. And I will not, of course, cover all the member states. We don't have the time to do that. But I would like to draw your attention to the situation in my country, in Belgium, where, in fact, we had we still have a number of laws that apply. We have laws in the field of electronic communication, specific Article 124 of the Electronic Communication Act, but we also have a specific article in the Criminal Code, 314 bis. We have also a collective bargaining agreement that could apply in that framework. And all that was supplemented until very recently by a case law that was going in all directions. So very difficult, in fact, for legal practitioners to determine what was allowed or not. So thanks to our regulator, we have now a recommendation which is in place and which basically give very concrete elements to justify the access of to this information. First of all, it is very important to put in place a policy. So to have a policy that, again, makes it transparent towards the employees, towards the personnel of the company, that they may have their data accessed. This is important because, as was mentioned by Christian, it is allowed in Europe to use the professional tools that you have received for your professional activities, also for private use, to a reasonable extent, of course. So, like you can call your bank if you want to make a transaction using your GSM, which has been provided to you or your smartphone by your employer, or you can use emails to make some bookings or whatever you like to do, which can be private. So what the regulator in Belgium has done is, in fact, stressing the need to allocate and to make sure that the employees have a chance to use those tools while marking them as private. And the most dramatic change that this may entail would be to have two parallel email systems. You could have the normal address, the Outlook address of the company, like Linklaters.com in my case, but then you offer access to the employees, to the staff, to their webmail address, Gmail or Hotmail, whatsoever, so that they can receive and send private emails. And, of course, that box would never be investigated or monitored. If it is not possible for any financial or technical constraints, this would be possible to classify them and to place them in a private folder, to mark them personal or private, in a way that whenever there is a need for investigation, of course in compliance with data protection laws, you then have to flag the information that can never be accessed and can never be read. It's in practice very difficult because, of course, you have also the issue that whenever you send an email, it's not only an email that you send to employees within the company, but you also have to send emails to third parties or receive emails from third parties. And there again, you may face the risk that you would infringe the telecom secrecy if you start investigating, if you start monitoring those emails. One way somehow to respond to that is to have a statement, a sort of a warning in your emails that show to the recipient or show to the person with whom you have a relationship, that these emails can be investigated. So it's not perfect, I know, but I think it's a way to comply as much as possible with these specific constraints.
Thanks for that explanation. I mean, I hear you. We have a number of requirements to fulfill. But let me be straight. I mean, I'm going to be sitting in the board and just tell them, okay, so this is the risk if we don't apply for leniency or immunity, 10% of your global turnover, fine. And we know that the level of enforcement from the European Commission is very high. I mean, what is the risk if we don't comply with data protection? Because I think that's a balancing exercise that they are going to make.
Yes, well, let's be very careful here again, because I think there is a risk, there is a strong risk. And I would like to turn to our European regulator. Thomas, what do you think about that? What is the current status and what is the upcoming future, I would say?
Hey, Tanguy, nice to hear from you again. Things are getting better. If you ask me sword or needle, I would plainly answer you, the needle is magically transforming into a sword. Supervisory authorities, and remember we have 28 plus now in the European Union, are increasing enforcement. They're looking at cross-EU enforcement actions based on sectorial approaches. And they're looking at enforcing data protection rules globally. Take the additional awareness also for data protection violations and data protection as a fundamental right. You get to see that, for example, fines are now being applied more frequently. The Spanish Supervisor Authority, the Agencia de Protección de Datos, just recently fined 2 companies for not complying with the cookie rules in the EU, 3,500 euros. The CNIL, the French Data Protection Supervisor Authority, again, just recently fined Google with its highest maximum fine so far, 150,000 euros. And the ICO in the United Kingdom has powers to fine companies up to £500,000. So consider that. And also, this sword is getting bigger, because you might have heard about the upcoming EU data protection regulation. There, certainly, the outreach, the scope of the European data protection rules are getting more clearly defined. As you have heard, the regulation provides for a clear and clearer territorial scope. Now, even if you're not established in the European Union, if you're offering your services or goods to European Union data subjects, you have to apply the rules of the regulation. And that means the regulators can intervene and enforce this regulation. The same goes if you are monitoring the behavior of data subjects in the EU. You're sitting outside, but you're monitoring them. That also means the scope of the regulation is opened. Again, the regulation will provide for harmonized powers of EU regulators. That means then you cannot come to one member state in the EU and hope that the maximum fine is 150,000 euros. No, by then the fines will be harmonized and every individual supervisory authority will have teeth. The regulation has provided especially for a fine up to 1 million euros in the Commission proposal, or 2% of the global annual turnover of a company. And the European Parliament has even upped the ante and has said that's not enough, that's pocket money. So in the future, if it's according to the will of the European Parliament, it's going to be 100 million euros or 5% of the global annual turnover, whatever is higher. So there are serious risks for non-compliance with data protection. And add to this that the regulation also has a specific codification of international cooperation. So supervisory authorities will have to work together on a global scale to enforce and exchange information on data protection violations. So my advice, get ready for that.
Well, thank you very much, and I think we will learn more about the draft EU data protection regulation in the coming hours. Let me now try to wrap up on what we learned, and I hope you learned during this session. First of all, I think the key word is really to be prepared, to anticipate, and I think it's important to have the policies implemented in each company to make sure that you have you can address quickly a request for investigation, be it, as I said, discovery or a subpoena that you receive or an investigation based on an antitrust violation. I think it's important also to foresee the transfer solutions. We talked about model clauses. We can elaborate on that during the Q&A. But I think it is important to figure out that, to look at the differences that you can have between one member state to the others, to ensure the formalities, review your notification, update them, look at the agreements that you have in place, make sure that you are addressing that in all the relationships which involve personal data in the company. And you shouldn't do that only at the level of the legal team. I think it's important to involve all the stakeholders that are subject that may be important in the setting of this kind of response to investigation. The employee representatives, the Works Council, the data protection officer, of course the management should be informed, and up to the parent company. That's important to have a system that works completely and that is also, there is a buy-in, in fact, from the entire group.